dated 19 September 2022, and I am assisted by Mr. Odhiambo. I have filed before the National Assembly the petition dated 19 September 2022, seeking the removal of Juliana Cherera, Francis Wanderi, Justice Nyang'aya, and Irene Masit, who I shall hereinafter refer to as the 4 commissioners. This petition, I entertain no doubt in my mind that you will find discloses reasonable grounds for them to be removed, and forward the petition to the President of the Republic of Kenya to appoint a tribunal and investigate the conduct complained about in this petition. Honorable members of the committee, let me start by commenting on the peculiar jurisdiction as well as the operating law that allows a person to present a petition before the National Assembly for the removal of a member of an independent constitutional commission. This is important because yesterday the counsel for the respondents appeared before you and said a lot of things as to why this petition should not be admissible before you. They said that the petition is not accompanied by an affidavit. They mentioned about cases of impeachment from the Republic of South Africa and political bias. As regards the accompanying of this petition by an affidavit in support of it, I would want at the very beginning to refer you to paragraph 230 of the National Assembly Standing Orders, which does not make it mandatory for a petition of this kind to be accompanied by an affidavit. It says the petition may be accompanied by an affidavit. I elected not to support it by an affidavit. And therefore, the fact that it has not been accompanied by an affidavit does not make it defective to be inadmissible, to be heard by the Honorable Committee. In terms of presentation of this petition, I'm going to structure my presentation in 4 thematic areas. Number 1, I shall seek to demonstrate to you the grounds upon which this petition has been premised, and then specific to one commissioner, that is Commissioner Irene Masit, I shall, over and above the grounds for the removal that applies collectively upon these the commissioners, I'll tell you reasons why you should forward this petition to the President of the Republic of Kenya to investigate her conduct and subsequently remove her from office. In doing so, I'll tell you she is not suitable, or her candidature is not suitable and qualified to hold an office as a member of the Iebc, not an independent commission. Let me start on the first ground that I have premised my petition to invite you to remove the 4 commissioners from office, and that is the ground of incompetence. Honorable members of the committee, it is my first submission that the individual and collective conduct of the 4 commissioners, to the extent that they reckoned that in the computation of the 50% plus 1 constitutional threshold or the legitimacy test must include rejected ballots, and they used that to refer to the result that had been declared by the chairperson of the Iebc, Mr. Wafula Chebukati, as opaque, was an act of incompetence. In inviting you to reach that finding, honorable members of the committee, I urge you to take it as a matter of public notoriety that the Supreme Court already pronounced itself on the issue whether rejected votes should count in the computation of the 50% plus one constitutional threshold, and its answer was in the negative. What this should tell you, therefore, is that to the extent that inevitably you will find that the 4 commissioners reckoned that the 50% plus one constitutional threshold or legitimacy test should be used, you must reach the inevitable conclusion that they had inability to successfully administer an electoral process that was subject of their conduct. The second ground upon which I'm premising my petition for you to find that these 4 commissioners are candidates for removal is that of the violation of the Constitution. And it is any violation. There is nothing like serious violation. If you interpret Article 251 in that matter, you are going to skew the spirit upon which it is predicated and premised. On this ground, honorable members of the committee, the 4 commissioners, on the 22nd day of September 2022, took oath as members of Iebc. By dint of the oath that they took, they were mandated and obligated to be bound by the principles and principles and values of public service delineated by Article 232 of the Constitution of Kenya 2010. It is important, that article is important because in my humble, honest view, it is one of the reasons as to why we have referred to as our constitution as progressive and an autochthonous constitution. It's very important because it helped in serving the purpose of us moving from the previous regime under which public officers, state officers, even if there were no independent commissions, constitutional commissions, it helped in laying down the principles that their conduct is supposed to be subject to. Specifically, honorable members of the committee, the 4 commissioners' conduct, to the extent that they issued strikingly similar statements with a contestant in a presidential election contest that they were acting as referees over, cast aspersions as to their impartiality in the electoral process that they were supposed to be administering. Impartiality is all about perception. There can be no more evidence to be adduced other than perception from a reasonable man's point of view to say that someone is impartial. So to that extent, I invite you to find that the 4 commissioners were impartial, and for that reason, you should forward this petition to the president to form a tribunal to investigate their conduct.
Sorry. Impartial? What did you mean?
Come again?
Partial.
Partial.
They were partial. We were partial, impartial.
They were partial, not impartial.
Thank you.
Yes. I said it casted doubts as to their impartiality. Yes. Let me move, secondly, as to the suitability of the candidature of Commissioner Irene Masit. Commissioner Irene Masit, as you might be aware, unsuccessfully vied for the position of Elgeyo Marakwet woman representative position. She did that. Her name was gazetted as one of the persons who contested for that elective position. What that should inform you is that Article 88(2) subparagraph A1 of the Constitution expressly prohibits a person from being appointed as a commissioner of the IEBC if that person has contested for an of an election within a period preceding 5 years from the date of appointment. Her appointment was subject to litigation in the case of Oganya versus Independent Electoral and Boundaries Commission Selection Panel and 2 others in Constitutional Petition E number 345 of 2022. And the good Lord Justice Mrima found her appointment to be violative of the Constitution. He, however, let Commissioner Masit to continue serving because her removal or an order for her removal would amount to subverting the preparedness of an election since they had already commenced that process. But that does not mean that she is now qualified to hold office as a member of the Iebc Commission. At the end of it all, honorable members of the committee, I invite you to convince your larger majority members in the House to vote in favor of this petition and forward it to the President of the Republic of Kenya to remove these 4 commissioners. I thank you, honorable members of the committee.
Thank you very much, Jerry. That was brief, possibly precise, but let me not impose my judgment on any of my committee members, but we would require some clarification. They'll ask you a few issues.
Very well.
Let me begin. Number one, you've stated that the 4 commissioners made it a point that sport ballots be included in the tally so that we are able to derive some decision or opinion as regards 50 plus 1 votes. Where and when did they say this? Do you have any particular evidence to rely on to show that they made this statement? Number 2, clarify to us, in as much as there is a court case you've quoted, when exactly did Commissioner Maset contest the seat you've alluded to? In which general election? And in particular, which particular seat in Elgeyo Marakwet did she seek? That is all. Vice Chair? No. Honorable Mushira?
Can I answer those before other questions come in?
Let's take about 2 more. Those are only 2. Let's have Honorable Mushira and Honorable Kagusha.
Thank you, Chair. Petitioner, in your petition, paragraph 17, you mentioned that the 4 commissioners violated the Constitution, the constitutional rule of law and good governance by the fact that they staged a dramatic revolt and walked out and gave a press statement. I would want to know, how does that violate, giving a press statement, how does it violate the Constitution and the principles of good governance? And finally, on number 2, you say that the 4 commissioners were involved in the verification, tallying, and tabulation of the presidential election result. Do you have evidence that they were involved in that tabulation and verification? Thank you.
Honorable Kagusha?
Thank you, Chair. Mr. Jerry, I would like to seek a clarification on what you have mentioned about Commissioner Masit. You clearly put that she had participated in an election within 5 years, and you say that she had actually been gazetted. Do you know on which political formation she had intended to vie, or in which political formation, when she was vying, she was in, and whether it has any implication as to where her loyalty in terms of political support would have been when she came in as a commissioner? And you have also pointed out that at some point the commissioners gave press statements that tied with a statement that had also been issued by one of the political formations. Which political formation was this? And do you think there was some kind of synchronizing of what was happening with the commissioners and that particular political formation? And do you connect in any way what is happening at this particular moment when this committee has started the investigation on these commissioners and the reaction of some of the political leaders in the country? Do you think there is any connection whatsoever on the conduct of the commissioners? Do you think these commissioners were acting or have been acting in the behest of certain politicians in the country? What is your take based on what you have presented here?
Okay. Jerry, you may now answer those ones.
Thank you, honorable members of the committee, for those 3 questions. I'll start by answering the question by the chair on where the recon by the 4 commissioners that 50% plus 1 constitutional threshold test posited by Article 138, sub-Article 4 of the Constitution was contained. If you look at the pleadings before the Supreme Court, their own pleadings, that was their take all along. That's number 1. Number 2, if you look at the detailed press statement that they released on the 10th day of August 2022, a day after, not 10th day, but 16th August, I'm sorry, I retract that, 16th August 2022, a day after the release of the results, they expressly communicated that. Evidence, whether I do not have, because I was under the impression that I am bound by the strict rule of evidence and admissibility thereof. I cannot bring before this committee a document that I'm not the maker. So I did not, but it's in the public domain.
Is the evidence available? Are you able to produce it, even if you don't hear any other place?
With ease.
Thank you.
On the question about dramatic revolt, at the results which the 4 commissioners had taken part in verifying, tabulating, and collating at the 11th and a half hour, and how that relates with the violation that has been imputed under Article 10.2. One of the values that has been provided for by Article 10.2 is transparency. And therefore, when they came out to dramatically revolt at those results that they had been participating in verifying, out of nowhere, when did this commission break out? It casts a doubt as to whether they were properly observing that element of transparency under Article 10.2c. Once again, the evidence of the tabulation is all in their pleadings before the Supreme Court. It was their conduct. Again, I cannot bring it because I'm not the maker of those documents. The question by Honorable Kagushia. Yes. On the political formation that Irene Masit had sought for election unsuccessfully in 2017, the Jubilee Party. albeit unsuccessfully. But that amounts to an election. As to whether her judgment could have been compromised by that and the connection of what is going on from certain quarters of the political class and her conduct, I leave that to any reasonable man to draw that conclusion. I don't think it's in my place to draw it.
Thank you. Let's have Osoro, followed by Wakili, Jane, then John, in that order.
Thank you, Chair. I want to understand, as a matter of possible jurisprudence, even for our own understanding here, on the matter of Irene Masit. Irene Masit, in this petition, falls in two folds. One, she falls on her suitability to be in office, and I think that is Article 88(2),
yes.
say. And she also appears now collectively, and possibly, for lack of a better word, she's found herself within the other three commissioners in your petition as provided for under Article 251. And that is now, I'm trying to read Article 251 on the element of incompetence and bankruptcy, vis-a-vis Article 88 on suitability to hold office. Do you still hold that she falls within, just your own opinion? It's a legal issue. Do you still that still the petition is still premised under her particular query is still premised under Article 251? Does she still fall within that threshold of removal of a tribunal? Do you require a tribunal to remove somebody from office on the basis of Article 88(2)? Do you require a tribunal? Do you require a parliamentary process system? Do you require a petition? Because the point is on eligibility, which is not provided for under Article 251. Suitability, Article 251. So what other, channel should we use to have her removed if we have to remove her? Because collectively placing her under Article 251 and there is 88, then there is a challenge on that. Number two, Article 81 on the conduct by the independent body. Independent body. I also need to understand, and this is again for our basic legal understanding and also to possibly help ourselves. Where do we draw the line? We are talking about an independent body, a body. So an independent body is generally the Iebc. Yes, the commissioners worked, or they still work with Iebc as a body. Bomas of Kenya was gazetted, as the place to, the gazetted as the place for the presidential elections, and that is it. Now, how do they separate their personal life or their personal self as human beings from the body? Because again, as I said, before another petitioner was here, there's a thin line again between expression of, one expressing himself as provided under Article 33, and then acting now within the office. Where do we draw the line? And finally, Article 73, 2, and I'll be very particular on where you are. 2B, I think that is where you raise the issue. And possibly Article 10, because that can be read together, 10.2. Now, on the point of honesty, I'll be very particular on honesty in the execution of their duties. Now, this is individual basis, because Article 81 is on the entire body. But this one talks about impartiality on your own individual basis as a state officer. Impartiality, honesty, 2B. Now, we are here relying on a press conference done by these people outside Bomas of Kenya. A press conference. where do we separate the truth from the lie? Possibly they went there to display honesty, because they went there, they wanted to be honest, and they decided to go there and hold a press conference. So how do we draw that line? And I think, again, this is for our basic understanding. Thank you, Honorable Chair.
Thank you. Thank you. Wakili?
Thank you, Chair. Jerry, I just have two issues which I'd like you to just clarify to the committee. Number one is in regard to the statement which the petitions made, which you alleged was similar to a statement made by a contestant, which the commissioners were expected to be an arbiter. Now, why I'm asking that question is because the committee would like to know who was the holder of the copyright of that statement and who did the plagiarism on the statement, who was copying who, and maybe also highlight to the committee what are these highlights. Were they word for word, or were they just alluding to the same direction? That's because you've said that you're relying on Article 251 in terms of incompetence. And does that then, when you copy the other, who copied the other? And when you copy, does it then, how does that, because from there you decide, the committee will decide who plagiarized against the other, if there's such kind of word. The other question is in regard to this matter regarding the Commissioner Masit. And you've alluded to election petition number 4522. We are not very familiar with that suit.
345.
345 or 22.
Yes.
Maybe kindly for the benefit of the committee, kindly, we'd like to understand the relevance of that suit in light of Article 88, whether the incompetence or the grounds of your petition are grounded on Article 88, or maybe that petition brought in matters of incompetence on the part of Masit. Again, walk us through on the gist of that that petition, and guide the committee. What was the ratio decidendi of that suit, and what was the obiter dicta? Thank you.
Jerry, I can assure you I'll not use heavy legal terms like my colleague here. Jerry, the aspect of incompetence does not come out clearly. I think it's the first thing that you explained to this committee. And you tied it to the tally. And there were memes all over social media. And if I recall, people would say in Swahili, hesabu za cherera. So do you think perhaps the tally, as given by the commissioner, was an unintelligible calculation, or do you feel the aspect of you saying that it was incompetence, how do you think it was incompetence on her part and not just an unintelligible calculation?
Thank you. John?
May I answer those? Very well.
Just make a note of it.
Yes. Now, I want to ask this. You're a lawyer by profession, correct?
That's correct.
Yes. And this petition constitutes the pleadings in this particular matter, correct? Now, I have issues with the dates. I want you to look at paragraph 1. You're saying these commissioners, first of all, the paragraph 1, you're saying the commissioners took the oath on 2nd of September 2021. And you have mentioned the names. You mentioned Juliana Cherera, Francis Madenge, Irene Masit, and Julia Sabonyo. I have known these commissioners by other names. Would you maybe just confirm to us that these commissioners also go by these names? Because I am not sure of a commissioner known as Francis Madenge and Justice Sabonyo. That is one. 2, look at paragraph 6. You're making reference to a conference, and paragraph 5 of your petition.
5 or 6?
Paragraph 5 and 6.
Okay.
You're saying that this is a press conference on the 15th of September 2022, 6 days after the rigorous exercise. Is that the exact date? Was it 15th of August or 15th of September 2022? On paragraph 6, you're mentioning 16th of September 2022. Is that the exact date? I want a clarification on those issues of dates. 2, would holding views similar to another person, because you have said here that perception is just enough. Will holding views held by another person amount to a violation of the Constitution in this particular case? Because you have said they held similar statements with the Azimio candidate. And that one you are pointing out is a ground as a violation of the Constitution. Then effectively on incompetence, you have mentioned Irene Masit, but I have not gotten you saying anything else about these other commissioners. Do you have any other issues? Apparently this particular bill will point a violation of the Constitution, incompetence, or gross misconduct, for example, as against the other commissioners.
Thank you. You may answer those ones.
Let me start by answering his question on the mention of Irene Masit specifically on the ground of incompetence. That is not what is contained in the petition. The ground for incompetence is individually and collectively against the 4 commissioners. Masit is referred to because her appointment as an Iebc commissioner was violative of the Constitution, and here as well I now want to answer Honorable Osoro's question, as well as constituting a violation of the Constitution to warrant a removal under Article 251 of the Constitution of Kenya 2010. The paragraph on names, that is paragraph, not on names, but the discrepancies on the dates that I have mentioned here, and in the petition, I want to mention that was an inadvertent error. The date should be 15th August 2022, not September. On paragraph 6, it should be 16th August 2022, and not September. As to holding similar views, whether that in itself constitutes an act of violation of the Constitution to warrant one to draw a conclusion of partiality, my precise and short answer is yes. I'll proceed to explain why. When these views are consisting of statements that have been subject to litigation previously, then you know you are partial. It was not a niche area they were discussing. The Supreme Court in 2017 had already made an express decision as to the matters that they were imputing in their press statements. Honorable Njeri's question on incompetency, whether I'm relying on, what was your question? As I didn't get it quite clearly on whether I'm relying on the 50% plus 1 constitutional threshold on incompetence or a violation of the Constitution.
You mentioned the tally.
Yes.
So my question was it, why do you think that it was incompetence and not just merely perhaps an unintelligible calculation?
What I actually mentioned was their interpretation of that computation as to whether rejected ballots should count in coming up with the 50% plus 1 constitutional threshold. And I'm saying that was an act of utter incompetence because there already exists a robust, clear decision by the Supreme Court, which had not been overturned. So what was informing their mind of stating otherwise? One cannot see any other reason other than incompetence. As to Wakili's question on who plagiarized whose statement, that is a matter that I cannot have exclusive knowledge over. All I know is that one statement preceded the other. So if it's the statement that preceded the other that can be construed to have been plagiarized, then that is a fair conclusion to make. On the relevance of the grounds under Article 88, sub-Article 2, again, I just now want to clarify Osoro's question, Honorable Osoro's question, whether Masit's grounds for removal in this petition, to the extent that she contested for an election in the 2017 general elections, should be predicated under Article 88 or Article 251. We have to take notice that there was a decision there was a constitutional petition filed before the High Court challenging her suitability and qualification for her candidature. And the judge reached the conclusion that she was not qualified to hold office as an Iebc commissioner. But the good judge, in his own wisdom, I do not want to say or lack thereof, said that she should be left to continue serving because her removal or a declaration for her removal would interfere with the process of election preparedness that they had commenced. That take you to the back because we have a live court order saying she is not qualified for appointment as an Iebc commissioner, but she is in office. That order already says her appointment was in violation of the Constitution, but does not make a declaration for her not to hold office. That therefore means that this honorable committee and the National Assembly at large assumes jurisdiction to investigate her suitability and her candidature as an Iebc commissioner, hence the presentation of this petition before the National Assembly.
Chairman, just for the benefit of the committee again, if that petition, I think, will form a major basis of our interrogation by the time we make a conclusion. Can you give us maybe proper citation of that case for our records, please?
I can't supply. I have a problem with pronouncing the first name, but it is G''Oganyo.
Yeah, the case now, we can just get it from the Kenyan reports.
Yes. Yeah. Very well. I'll supply that to the committee.
Is it part of the pleadings in the petition? Or?
That is correct. It's part of the pleadings in the petition.
That is sufficient. However, again, on that particular one, do you still hold the position that her removal should be prosecuted under Article 251? I mean, really, because you've prosecuted very well on, in my view, you prosecuted very well on the court's decision, on, suitability and everything. But still, I still don't find the ground within 251 because your general petition is, really relies on Article 251. And could there be a possibility, as an advocate yourself, to go back to court with the very decision that you hold? And seek, because the High Court, of course, holds jurisdiction for constitutional interpretation, using their own decision and seek interpretation for that.
Interpretation for?
There is already a court decision. You call it a court order. I don't know whether it's an order, it was under, the matter was under, I don't know. We'll have to go through it. I mean, the reason why she was allowed to stay in office is possibly to hold elections. The elections are over. I mean, do we need a petition to have her removed, or you go to court for review?
I would say it will depend with the school of thought that you belong to. And the school of thought that I belong to, my answer is still yes. That is so because there is no positive order declaring her removal from office after her function of administering the 2022 general elections is dispensed with. So you still need to institute removal, proceedings for removal for Honorable Irene Masit before the National Assembly under Article 251, because her appointment in itself constitutes a violation of the Constitution.
Let's hear from the Vice Chair now.
Chair, before just a clarification. Just on this, because identity is important.
Yes.
I need your feedback on identity.
Oh, very well, very well. Yeah. To the best of my knowledge, I have referred to the persons as Juliana Cherera. I want to believe she is the chairperson of the IEBC. Sorry, vice chairperson of the IEBC. Her counsel seated here yesterday said otherwise. A factual, simple check on her background indicates that as her name. I do not know any other name that she holds. I also hold the view that it is Francis Madenge and Justice Abonyo. I have no information as to other persons holding office as IEBC commissioners other than these three individuals whose identity is in question.
Do you know their other names?
I don't know.
Do you know, I mean, it's public notoriety. That's what we say in law. You must have read even today's papers. You must have listened to the TVs, watched TVs last night, listened to radios. What other names are used? In each of the, especially for Francis Mafenge and Justice Abonyo, do they have other names that are known by Kenyans?
I wouldn't know, Honorable Chair. But for the avoidance of doubt, I refer to them as commissioners of IEBC. These names could contain identity for persons holding office as commissioners for IEBC. I don't think whether it is disputed whether there is a Francis as holding office as an IEBC commissioner.
Any other Francis? There is no, you do not think there is any other Francis who is a commissioner of IEBC?
There is
apart
no
from the one you have named as Francis Mathenge?
Yes, so the person referred to as Francis Madenge here is the Francis that exists as a commissioner in the IEBC commission.
Same applies to Justice Abonyo?
That is correct.
All right.
Thank you, Mr. Chairman. Words, Chief. Very, very precise. I believe quite also focused to your petition. Two quick questions. Number one, EU seeks equity must do so with clean hands. And for that reason, you have accused the 4 IEBC commissioners of having worked at the behest of certain forces. What motivates you yourself to bring this petition before this committee? Could you as well be working at the behest of other people? That is question number one. Question number two, and we seek clarity. A question was asked here earlier, and I would wish that you also address that question. And the question was as follows, paraphrased, that in January, the chairman of Iebc and commissioner, the two other commissioners that you have not petitioned against, their terms will be expiring and they will be leaving office. You have now brought a petition to remove the 4 other commissioners, and therefore, that means if your petition succeeds, and this committee recommends to the through Parliament, and Parliament adopts the formation of a tribunal, and eventually these commissioners, if you look at Article 251, are either suspended, taken through the process of the tribunal, that means there will be no commissioners at Iebc. How does the country, given the centrality and the constitutional importance of the institution of the Independent Electoral and Boundaries Commission, as an advocate, as a citizen, how do you foresee that situation, and how does the country navigate through that situation, knowing that there are by-elections that are expected, and there may be more that are expected? We are at a period where we are almost approaching the constitutional deadline for review of electoral boundaries. How do you see us going through that particular situation?
My answers will be very brief. I'll commence with the last question that you asked. As to whether when the 3 commissioners that are left in office proceed to terminal leave, and I believe they should have already proceeded to terminal leave, and these 4 commissioners whose conduct potentially will be under investigation are suspended, the balance that one must create in ensuring that the IEBC as a commission and institution should proceed to carry out its mandate. The answer is very brief. The end cannot justify the means. We cannot have persons who have violated the Constitution being in office because of duties expediency. That is not what Kenyans aspired to do in 2010 when I was in Form 1 by passing this Constitution. It's very far from the truth. As to whether the functions of the IEBC will be halted, definitely they will be. It will not be the first time. Remember, we were supposed to be having elections in 2012. Those elections were pushed to 2013. Section, I think it's 40 or 48 of the Elections Act, precipitates a scenario or a situation where an election can be postponed. The by-elections are not a matter of urgency. They can be postponed for the IEBC to be filled with competent people that have integrity and high standards of professionalism, capable of performing the functions that are bestowed upon them by law.
The second one on your motive, and as you answer that, you also tell us, why are you petitioning against the 4, and you are not petitioning against the other 3, and yet we have also had complaints against them?
What motivates me is the Commission of Impunity and the fact that the law gives me an avenue to redress that impunity under Article 251. There's nothing that should motivate me more than a legal provision for redress of a clear, demonstrable impunity. As regards to why I have not petitioned the rest of the 3, whereas there are complaints against them, it is important to remember that the Supreme Court vindicated them that they were right. The complaints are therefore misplaced. and should not be said by any serious person in this country.
What is your test for seriousness? Very on a light note. On a light note.
I beg not to answer that.
Thank you, Jerry.
Just on that, on what you say that the Supreme Court vindicated them in the election, were they on trial themselves as commissioners?
They were not on trial, but their conduct, insofar as the tallying and declaration of the results are concerned, became under scrutiny and questioned. And that conduct was vindicated by the Supreme Court. The Supreme Court said they are right. The Supreme Court said these 4 commissioners whom I seek to have removed were wrong.
Thank you, Jerry.
Chair, if I may, there's a matter of great concern.
Yes.
I see Kagusha is out, but Jerry, we were wondering whether you were lost or you were caught up in the traffic jam because you were late.
No. I had earlier thought that my session was to begin at 2:30 and not at 2. That's why I was late, and I apologize to the honorable members of the committee.
I think you may be right that either the notice we sent to you or what we put in the press gave you 2:30.
Yes.
So the committee, being a very serious committee and anxious to do its job, may have sat a few minutes earlier than 2:30, and that is when the concern was raised. I think we exonerate you from any blame whatsoever, because your notice was, your session was to start at 2:30, and by 2:30 you were here, and we have finished before 3:30, which is when you were supposed to actually be released. So thank you very much, Jerry. And we've heard your petition. We've listened to it carefully. We confirm to you that we are going to seriously consider it. The way you've written it, presented it, and whatever else we need to look at, including confirming whether a gentleman known as Francis Mathenge Wanderi is the same as the Francis Mathenge you've named. And the other gentleman is called Justice Nyangaya, whether he's the same as Justice Abonyo. We'll be confirming that so that we see whether there is merit in your petition and whether it requires the action you've prayed for. So thank you very much. I believe your assistant doesn't have any issues to raise. He's assisted you by being present and giving you that most needed company, which is required sometimes when you're doing things as serious as what you are doing this afternoon. So thank you very much. I remind you that on Monday, the respondents will be here. They will be actually presenting their defense. They may be attacking your petition in one way or the other. So we begin at 10 a.m. and you'll be afforded time to cross-examine if you're here. And we proceed again to 2:30. Again, another one will be here. You'll be offered an opportunity to cross-examine if you so desire. The same applies to Tuesday. So if you wish to be present and you cross-examine, you have the right to do so. Otherwise, thank you very much. And you'll be hearing from us, or you'll be hearing from us through the House of Parliament. Thank you very much.
I thank you, Honorable Chair.
You may be ushered out now. Thank you. Thank you very much, honorable members. I most sincerely thank you because we've come to the close of the afternoon session, and we also come to a close of hearing petitions from the 4 petitioners. The time left now, the session continues on Monday and Tuesday so that we can afford an opportunity to the respondents to make their representations. We are required by our standing orders, we are required by the law, administrative, constitutional, and otherwise, to give respondents a fair and just hearing. Therefore, we've set 2 days, 2 clear days for them to come and respond to the issues that have been raised by the petitioners, including accusations, statements, pleadings, whatever it is that they need to respond to. So we will actually have that opportunity on Monday and Tuesday. Thank you, the Secretariat. You've been very helpful to us, and we continue to expect to receive that help as we move on with our matters. Thank you, members of the press. You've been with us throughout. I hope this has been relayed to the country that we are within the law, we are within the standing orders of the National Assembly in conducting these proceedings, because that is what we are required to do. And we have done the best we could so that we hear everybody in the best atmosphere and in the best way possible, so that nobody feels we've not accorded that sufficient time required to present the matter and to respond to the matter. So with those remarks, today's proceedings are hereby adjourned, and we resume on Monday at 10 a.m. That's when the formal proceedings begin. For the members, we may come in at 9 o'clock to do a bit of in-house to get ourselves ready for those proceedings. Thank you very much. Have a good weekend. Let's meet on Monday.